review because it's a small condensed version of the class. In the dark ages of my undergrad years, I used to take all my notes and condense them into like a 30-minute lecture, and then I would listen to that. That way, rather than try to read a book, I could listen to a 30-minute lecture on an entire course. I could do an entire college class usually in 30 to 45 minutes, because that's usually all the real information that's there. You can get a law degree in an hour and a half. Now, during this time, don't question me. Don't stop. I start going. It's all kind of rote memory thing. So, like, this will be the only thing I remember when I have dementia. So, don't interrupt me. Try not to move around because I get distracted and I lose where I am. So we got to go. So, if you've got a phone, you want to tape it. I'll start this in a few seconds. I'll get you ready. So, who's taping? You taping? You want to tape? I'm going to tape. All right. Gracie has a copy of this someplace. Somebody actually put it on YouTube once. But here we go. Ready? We're going to start in 5, 4, 3, 2, 1. Real estate is a licensed profession. Licensed profession means you have permission from the government. It is the executive branch of the government that gives you permission for licensing. The executive branch of the government, under Chapter 20 of the statutes, is in charge of regulating and enforcing. A license gives you permission, authorization to engage in a profession. This makes you an expert, a professional. You are someone who may be compensated for the services of real estate. As an expert, you are considered qualified. Your license is prima facie evidence of your qualification to engage in any of the 8 services of real estate. Our services of real estate, including advertise, buy, appraise, rent, sell, auction, lease, or exchange, do not have specific additional certifications. The license itself is prima facie evidence of certification and therefore qualification. You are required to be licensed in order to be compensated for any of the services of real estate unless exempt. There are specific exemptions. If you are specifically exempt from the real estate licensing requirements, you may be paid without having to have a particular license. Example being, if you are court appointed. A court appointed individual has license in that the government has appointed them. You don't need a separate real estate license. Court appointment or power of attorney is adequate. A person who has power of attorney is referred to as an attorney in fact. There are things that overlap the real estate industry that appear to be real estate, but they are not. Cemetery lots, for an example, that's not real estate. Hotels and motels are not real estate. Renting space in a campground is not real estate. Compensation for those activities does not require a license. If you work directly for an owner-developer and are paid salary only, that's an exception to 475 of the statutes. Now, if you get any kind of bonus or incentive, a license is required. A simple promise to pay is a violation of 475 in that you must have a license to be paid or expect compensation for any of the services of real estate. Now, the Department of Business Profession Regulation regulates all professions. The Florida Real Estate Commission is appointed by the governor and is specific to real estate. The governor appoints the Florida Real Estate Commission, and they handle all the executive functions on behalf of the state. The Department of Business Profession Regulation is employees. They are hired by the state. They handle all the administrative functions. The department does things such as investigate. They are going to handle recommendations to the state, and they maintain records. The Florida Real Estate Commission makes all decisions. So the department recommends, the commission makes all decisions. Now, if you are licensed to engage in the mortgage industry under 494 of the statutes, you may be paid for mortgages, but not real estate, and vice versa. Licensed to handle real estate, not paid for mortgages. So the referral fee handed by a mortgage company to the real estate licensee is a violation of the license law, and in fact 2 separate categories under 455. 455 being licenses in general. A person receiving money from a mortgage company is in violation of 494 because they don't have a mortgage license, and 475 for being compensated without a license. The rules and regulations of the commission. The rules and regulations of the commission are under 61J2. They apply specifically to licensees. 61J2 is the rules. If I have a real estate license, I am subjected to 61J2. Therefore, you need to have a real estate license to be suspended. So violating a criminal act is something that's handled through the criminal codes. 475 is a felony if you violate that. That's criminal. There are civil penalties that may also be issued. Those are in money. But over and above that, sanctions against your license would be under 61J2 of the statutes. Now, In order to receive a license, you have to be at least 18. You have to have a high school diploma or its equivalency. We do waive fees for people in the military for a period of up to 60 months. 60 months is 5 years, but since everything else is 2 years, we switch it to 60 months, so you realize it's different. So if I'm active duty military, we waive fees for a period of up to 60 months. You do not have to take the real estate course if you have a 4-year degree in real estate. We exempt you from the class if you have a 4-year degree or if you're an active member of the bar. Active members of the Florida Bar are also excused from continuing ed. Continuing ed is handled through their attorneys, continuing ed. If you have a 4-year degree in real estate, you still have to do continuing education. Continuing education is an update on things that have changed over the last cycle. Your renewal cycles are 2 years. No requirement to do the pre or post licensing with a 4-year degree in real estate. 4-year degree, no classes for me, but every 2 years I do CE. We allow you to get licenses in other states based on your education experience here in Florida and vice versa under mutual recognition agreements. States that have mutual recognition allow you to simply take a 45-question test and avoid all the school and other requirements. If you are trying to get a license through mutual recognition, you must be a resident in another state. Once you come to Florida, we will consider you a Florida resident after a period of 4 months. After 4 months, you're no longer allowed to take your license through mutual recognition. You have to go through the class like anyone else. Post-licensing is a requirement after your first cycle. Your renewal cycles are on a fiscal year basis. They expire September 30th, March 31st, odd or even years. During your first cycle, you have to take a 45-hour post-licensing class. Failure to do post-licensing renders your license null and void. Void meaning it's gone. You don't have a license anymore. Null and void if you fail to do your post-licensing. After you successfully complete post-licensing, a continuing ed course is required every 2 years. Continuing ed cycles every 2 years. It's a 14-hour course. If you fail to do continuing ed, your license expires. That means you still have a license, but it's no longer active. It would be considered involuntary and active. You'd have to revalidate your license. We have a 12-month period of time where you can do it and pay a late fee. In the 12 to 24-month cycle, you have a reactivation course. After 24 months, your license is null and void. So after 2 years, your license is void. To be compensated, you must be active, valid, and current. You're considered active in Florida when you have an employer. Employers may be brokers, owner-developers, or government agencies. And over and above that, you have to be on record with the Department of Business and Professional Regulations. So you must be employed and on record simultaneously. If there's any change in the information on your license, you must notify the department within 10 days. So if you change your employer, 10 days. Change your address, 10 days. Change your name, 10 days. Pretty much anything that requires you to change information on an existing file, the notification period is 10 days. If you change your residency, you've moved out of state. Third party, 30 days. Since you have 2 different states to notify, we give you 60 days. So a change of residency means you've moved out of the state of Florida, but wish to maintain your active license in Florida. You've moved out of the state, you must notify the new state and must also notify the state of Florida. However, you still moved. So you have to notify the state that you've moved and changed your address in 10 days. Within 60 days, you must handle the change of residency requirements. It is a double tap answer. Both are required. Brokers may have unrelated companies. A broker with 2 or more unrelated companies is said to have multiple licenses. Brokers have multiple companies so that they can keep people apart. As a broker, you have multiple licenses because you have multiple personalities. As a developer, you often want to have more than one project operating simultaneously. You want to be able to group your staff together and take them from project to project. Developers with more than one project have group license. Brokers, multiple license. Developers, group license. Brokerage relationships are required to be disclosed in residential transactions. Residential transactions are defined as 4 units or less, agricultural property of 10 acres or less. Disclosures of your relationship include a possible single agency relationship or a possible transaction broker relationship. A single agent is a fiduciary, an undivided loyalty, trust, confidentiality, and obedience. A transaction broker is limited representation. Limited representation requires you disclose material fact as it relates to building, land, and contract, but do not discuss people. If you are a single agent for one party in a transaction, you must notify all others in writing that they have no brokerage relationship. Single agent for one, no brokerage relationship to all others. As a transaction broker for one, transaction broker for all. The default relationship in Florida is transaction broker. Questions that say that you have a listing and ask you what is your responsibility, assume you're transaction broker unless told otherwise. Transaction brokers do not give advice. Transaction brokers provide limited representation. They facilitate. They do not have duties of loyalty and obedience. A transaction broker instructed not to show property on a Saturday would simply ignore the instruction and show it anyway. A single agent does have the duties of obedience, trust, confidentiality. A single agent given instructions would obey those instructions. Single agents represent clients. Transaction brokers work with customers. We always disclose material fact in all circumstances. This includes things that are not readily observable. So building defects must be disclosed. If the roof leaks, you tell people. If the roof leaked and they fixed it, you tell people. If there's a sinkhole in the front yard, you tell people. If the neighbor next door has a garage band and plays real loud, that's an interesting story to share, but not a necessary story. The fact someone has died in the house is not considered material in Florida. So the fact that there's ghosts running around the backyard, not something that needs to be disclosed. Designated sales associate is unique to a non-residential transaction, often asked about where two real estate associates operating as single agents in the same transaction and the same office. If it's non-residential, they may do so with a form referred to as designated sales associate. Designated sales associate is two single agents in the same office and the same transaction. A designated sales associate must be a non-residential transaction. Offices currently may either be a web page or a physical location. Either way, they're said to have an entrance. It is the door, if you're a physical location. It is the point of contact page of a web page. A brokerage office is required by statute to maintain an entrance sign. All entrance signs will have the phrase licensed real estate broker. Licensed real estate broker, you can abbreviate the word license. All office signs, whether web page or actual door, will have the phrase licensed real estate broker. All office signs will have the name of the broker in charge. The individual broker who's in charge will also be on the sign. Name of the broker, the phrase licensed real estate broker. If you have a trade name, the trade name will be added. That's an if you have a trade name. You're not required to have a trade name. All advertising must have the name of the broker. This could be just the trade name. All advertising will have the name of the broker. If an advertisement has the name of a sales associate in addition, the last name of the sales associate is also required. Now, all advertising includes promotional items such as key rings or water bottles. It includes things like t-shirts and hats. You must have the name of the broker as registered. All that's required is the name of the broker as registered, so a billboard with just the company name and nothing else is in compliance with state statutes. Deposits are often given traditionally as a negotiated item. They're referred to sometimes as escrow or binder money. Associates who receive escrow or checks must turn them over to their broker immediately. Immediately is defined as no later than the next business day. Business days are not Saturday and Sunday or holidays. Everything else is a business day. So an associate who receives money on a Friday would have to turn over the broker on the next business day, which would be Monday. Brokers deposit money third day following the original receipt, so the first day doesn't count. So the money received on Friday is turned over to the broker on Monday. He may hold on to it Tuesday. It's going in on Wednesday. Escrow money in Florida must be in a Florida bank. By bank, they also mean Savings Association, Mutual Savings Bank, or any other Florida lending institution. Credit unions are also acceptable. Stockbroker is not acceptable. You cannot maintain your money with a Florida stockbroker. You cannot put escrow money into Bitcoin. Post-dated checks are acceptable with seller's permission. Anything that's unusual is permitted with seller's permission. It does not require buyers and sellers' permission because the buyers are the one who issue the check. There are inevitably disputes. Disputes require you notify the state within 15 days. It's a new file. Anything that's new file, 15 days. New file, 15 days. Remember, 10 days for changes of information on an existing file. New files, 15 days. You then must start a settlement procedure which contacts a third party. Third party, 30 days. Third party, 30 days. You must start your escape or settlement procedure within 30 days, and this is overlapping. You have to notify the state within 15. You have to start your escape procedure within 30. It's not a total of 45. The days overlap. Upon settlement of your dispute, you have to notify the state within 10 days of the settlement of the existing dispute. Settlement procedures include mediate, arbitrate, litigate, and escrow dispersion order. Mediation is non-binding. It is a non-binding negotiated solution in front of a mediator who's there to make sure that the negotiation complies with the rules. Arbitration is binding, but does require the parties agree ahead of time to be bound. Judge Judy is an arbitrator. Escrow disbursement order is binding only on the broker. It comes directly from the FREC, so it only has the authority to direct the actual broker. If a broker requests an escrow disbursement order, there's a cap at $50,000 because in the event an escrow disbursement order is overturned, FREC's recovery fund will pay. If your recovery fund has to pay because an escrow order is overturned, there's no recourse against the broker. If following an escrow disbursement order, FREC has got your back. They'll pay, they'll cover court costs and attorney fees, no recourse against the broker's license. All commissions are negotiable. There is no such thing as a set or standard commission. Commissions are regulated under the Sherman-Clayton Antitrust Act. Therefore, two brokers conspiring together to set prices are guilty of price fixing, a violation of Sherman-Clayton antitrust law. Two brokers conspiring together to divide up territory are guilty of market allocation violations, again, a violation of the Sherman-Clayton antitrust law. Virtually all questions that have two or more brokers getting together seem to do so at lunch. Beware questions where brokers are at lunch. Assistants are assumed to be non-licensed, unless they specifically say licensed assistant. Assume they're to be non-licensed. Therefore, earning any kind of commission or bonus is impossible. You don't have a license. Also, they're not allowed to do anything that involves negotiating or providing access. An assistant may not start your presentation because you're running late in traffic. Doing a presentation is considered a professional activity. Assistants may not provide access to the house. An assistant may drive a customer to a listed property, follow them inside for security purposes, drive them back where you present an offer, because since they had no interaction or provided no access, they violated no law. Your assistant can hand out brochures at the open house, but the assistant cannot have an opinion on whether or not the schools are nice. Not all companies are allowed to broker real estate, but the companies that are allowed to broker real estate must have the person with any kind of authority to be an active broker. So managerial capacity at a company requires active broker status. If you wish to open a broker, you must hire a broker to broker for your broker, because only brokers are allowed to broker. Sales associates may own the company as stockholders or limited partners, but they may not in any way, shape, or form have any authority. If you are a company that is set up as a real estate investment trust, we will not allow you to broker real estate because of the structure of the company. If you're a corporation sole, you're a church, you may not register as a real estate broker. If you are acting in the capacity of a joint venture, two registered brokers cooperating together, though you are brokering a real estate transaction, no additional registration is required. So a joint venture is a structure that can perform a real estate brokerage activity without registration. There are inevitably complaints. Complaints are issued by the public. Anyone is allowed to complain. You may complain anonymously. Complaints are then screened to see if they're legally sufficient. Legally sufficient complaints are investigated. Once investigated, they will sit before a probable cause panel. If the probable cause panel decides there is probable cause, you have option to go to a hearing. If you stipulate, meaning you agree and you have no dispute, if you stipulate, you go to the informal hearing, where you basically plead guilty, beg for mercy. Final order will be issued by FREC directly. If you wish to present a defense, you go to a formal hearing. A formal hearing is in front of an administrative law judge. The administrative law judge will then write up the recommended order and then in front of FREC for final order. You may appeal a final order. Only FREC may issue any kind of decision as it relates to any administrative complaint. Now, if you are a real estate office and you have committed a minor offense, such as you forgot to notify them of a change of address and time or your sign's not complete, you would get a notice of noncompliance. So the least severe penalty overall issued directly by the Division of Real Estate is a notice of noncompliance. The most severe penalty is a revocation. Revocation is permanent. Administrative penalties, again, are issued by the FREC. Civil damages are ordered by civil court. Civil damages include compensatory or actual damages. Actual damages, payback what was actually lost. Punitive damages or punishment. And then, of course, criminal penalties include jail. Those are done by criminal court. Civil, criminal, and administrative operate independently, though they do communicate with one another. If the recovery fund has to pay because a civil judgment is awarded, that's misconduct. Think M&M. Misconduct, mandatory suspension. Misconduct, mandatory suspension. FREC will only pay back actual damages, and its purpose is to reimburse the public for financial injury. The FREC does not pay the licensees for non-payment of commission. They will pay the public for financial injury. Now, the recovery fund reimburses for misconduct, you will have a mandatory suspension. So paying for misconduct, FREC is on the attack. Follow an escrow disbursement order, FREC has got your back. But paying for misconduct, FREC is on the attack. Landlords in Florida must maintain their escrow in a separate account in Florida. Again, we have the same rules. If a check is being returned, 15 days. If a landlord is returning a deposit, they have a 15-day window to do so. If they wish to file a claim, a 30-day window to do so. Landlords in Florida, if they keep advanced rent or they keep damaged deposits, must maintain it in a Florida escrow and return the monies in 15 days if no dispute. Must file a claim within 30 days if they have a dispute. The civil rights laws also are copied here in Florida. Civil rights laws include the 1866 law, which addresses race and race only. All race questions will address either black or white. Once it mentions black or white, it's a race question, there's no exception. In a race discrimination question, they'll mention a real estate sales association speaking with either a black or white person, and then you know it's a race question, there'll be no exception. If they use any other phrase, it's not a race question. The 1968 law, which addresses all other categories, race, color, religion, sex, national origin, disability, and family status, does not address commercial property, and it's exempt the single-family owner-occupied not listed with a broker. Owner-occupant of a duplex is not in violation of civil rights laws if they wish to discriminate against any category they wish, with one exception, that being race. If you are an exclusive club or you are a church, then being members only is not a violation of civil rights laws. Members only is being exclusive. It's not a violation of civil rights law. The Consumer Financial Protection Bureau requires full disclosure of all information on land being sold interstate. The Interstate Land Sales Full Disclosure Act is enforced by the Consumer Financial Protection Bureau. You must register developments that have more than 100 lots. The word bureau tips you off. It's the only time that we have to wheel with 100 lots. So bureau, it must be the feds. Bureau, it's the feds. 100 lots or more must be registered. Title. Title is a theoretical bundle of rights consisting of disposition, use, possession, and exclusion. The degree to which you hold title is an estate. Estates are divided into freehold and non-freehold estates. Everything's in twos. Freehold or non-freehold estates. Non-freehold estates or leaseholds could be under estate for years, specified contract beginning and ending date. Beyond the estate for years, it's a holdover. A holdover who has permission is a holdover at will. Without permission, a holdover at sufferance. Freeholds include your fee estates. Fee estates are forever and ever. Freeholds have an indeterminate period of time. A freehold estate, forever and ever, with no limitation, is called fee simple. All estates are carved out of freehold fee simple. Another type of freehold is tied to the lifetime of someone or something. It's a life estate. If a life estate exists, the original grantor, one who has passed a freehold estate to another, the original grantor retains an estate in reversion. It reverts back to where it began. Freehold fee simple, back to the beginning. Estate in reversion. If it goes forward to a third party, that's a remainder. Remainders that are named are vested. If they have to do something first, they're contingent. You may own property together with your spouse in the entirety. In Florida, married couples are an entire unit. Ownership in the entirety, husband and wife with right of survivorship. The last spouse alive is now owner in severalty. Severed means to be cut off from all others. Ownership in severalty may be conveyed by will. If you have a joint tenancy, like a property in the entirety, survivorship is also there, but it's not limited to the married couple. Two or more people may have a property jointly. Last one alive becomes owner in severalty. Two or more people may own property concurrently without survivorship under a tenancy in common. The three brothers who own property together and may will their share, once we mention it's their share, that's a tenancy in common. A condominium is an example of a tenancy in common. A co-op is a corporation that owns property in severalty, and the stockholders are able to occupy under proprietary lease. The big difference being a co-op is an artificial person. It owns in severalty. A condominium is more than one people sharing tenancy in common and then having individual deeds for their airspace. Now, if you live on a lake, that's an appurtenance, a benefit that you have that you don't actually own. The living on a lake is referred to as littoral rights, large lake littoral. If it's moving water, it's riparian rights, rippling river riparian. If you live on a lake and the lake goes down, receding water is reliction. Giant cat licking the lake, reliction. If you live on a river and your shore washes away, erosion. But erosion results in accretion downstream. Accretion is the buildup of the alluvium that resulted from erosion. Things permanently attached to land become in their own right real property. They are called fixtures. A doorbell in the house is a fixture. A ceiling fan in the house is a fixture. Once it's permanently attached, it becomes part of the real property. If I have a tree, that's land. If I have a house, that's real estate. Anything that includes appurtenances collectively referred to as real property. Now, if you have a document that conveys property from one party to the next, if it's done voluntarily, that's called voluntary alienation. A deed is an instrument of voluntary alienation. A will is an instrument of voluntary alienation. Both convey title. In Florida, a deed will contain a warrant of season, which is a statement that owner owns and has the right to sell. A covenant or warranty that says owner owns and has the right to sell is found in all deeds except the quitclaim. The quitclaim deed gives up any future or present interest in property without warranting any future or present interest in existed to begin with. Now, in the extremes, the general warranty deed has warranty forever. The quitclaim deed, warranty never. A bargain and sale deed, one step up from the quitclaim, warrant of season, but no warranty of title. I give you a bargain and sale deed when I own it, but I know it's broken. And the special warranty deed, used by developers and governments, this warranty is only for the present grantor and provides a surety bond for all other warranties. So in rank, quitclaim deed, no warranty at all. Bargain and sale, warranties only season. The special warranty deed, warranties for present owner alone. And the general warranty deed, warranties all the way back to the root of title. A special purpose deed is any deed signed by someone other than the grantor, regardless of category of deed. Constructive notice is not recorded in Florida to show ownership of property. Recording a document is not a requirement. Therefore, a deed does not have to have notary seals. Notarizing or acknowledging a deed is not a requirement in Florida because you do not have to record the document. You may simply move in. Actual notice is all that's required. Contract is mutual promises. Mutual promises that are between two parties are bilateral. If only one party has made a promise, it is unilateral. A mutual promise with enforceable rights is a contract. Contracts that convey real property or exceed 1 year must be in writing to be defensible in court under the statute of frauds. In order for a contract to be legal, valid, and enforceable in Florida, it must have a legal object. I cannot take you to court to enforce performance of an unlawful contract. Contracts that cover under the statute of frauds are referred to as formal contracts. They must be in writing. They have a 5-year statute of limitations. Parole or verbal contracts are still enforceable, provided the agreement does not exceed 1 year. Now, brokers are allowed to prepare listing contracts, sales, and option contracts because even though that's considered the practice of law, it falls within the purview of our license. They are not, however, allowed to prepare a deed or a will. Listing contracts that they may prepare include the open listing. The open listing is all brokers in Florida simultaneously have the ability through the doctrine of procuring cause to be compensated for their activity. If you present an offer that gets accepted and goes to closing, that constitutes an open listing. You're entitled to get paid. The exclusive right of sale, on the other extreme, must be in writing to be defensible. The exclusive right of sale, the broker earns compensation even if the owner sells the property themselves. The exclusive, also known as exclusive agency, is an agreement where the owner has reserved the right to sell himself and not pay. Under exclusive listing, typical for commercial property, the seller may sell himself and not pay at all. Now, if a contract is fully performed, it's an exception to all the other statutes requirements. So a fully performed contract is said to be executed. Now, an executory contract is one that's not yet finished. Executory is still got something left to be done until performance. Executed is fully performed after performance. That's why in a wedding, till death do you part, because until one of you is executed, it is still executory. Now, terms of a loan are found in a note. In terms of a loan, if you're borrowing money, the terms are found in the note. The mortgage document is used as collateral In the state of Florida, the mortgage document pledges as security of the debt. It hypothecates to pledge without delivery of title or possession. The mortgage document pledges the property as collateral for the debt. Therefore, a corresponding note must be included. So mortgages in Florida must be recorded in order to be effective. So constructive notice of a mortgage is required. Constructive notice of a deed is not required, but constructive notice of a mortgage is required. Typically, however, the mortgage company will require you to record the deed as well as a condition of the mortgage loan, not as a state requirement. Mortgages that are recorded are effective once paid off. They must be removed by a notice of satisfaction. A satisfaction releases the mortgage lien. So a mortgage is paid off will have a satisfaction recorded. Mortgages are defined by their acceleration clause. An acceleration clause speeds up the due date when someone is significantly in default. Mortgages typically will also have a due on sale clause. The due on sale clause prevents it from being assumed by a new borrower. Florida is a lien theory state, so we have mortgages. Our mortgage is going to hold the title as collateral for the debt. Whereas in a title theory state, the mortgagee or the lender holds title. California is a title theory state where they own the house until you pay it off. Our categories of mortgage include the government and conventional loans. Government loans, also known as non-conventional, include the FHA and VA loans. FHA has a mortgage insurance premium that the borrower pays on behalf of the lender. The VA has a guarantee, a similar insurance, but paid by the government. FHA, MIP. VA has a guarantee. Ginnie Mae buys your FHA and VA loans. Ginnie Mae, FHA, VA guarantee loans. Now, the conventional loans have a private mortgage insurance. They're typically bought by Fannie Mae. Fannie Mae likes the big banks. Fannie Mae likes it big. So FHA, MIP. VA has a guarantee. Conventional loans, PMI, they were jealous, that is why. Ginnie likes the government, Fannie likes the big banks. Title insurance assures a title search was done correctly. The lender's title insurance is a transferable policy because it's sold to new investors. Borrowers also will have a title insurance, but it's not transferable because once the title trades, it moves on again. Mortgage loan qualification is done monthly. Everything's monthly. The obligations ratio that the banks use for the VA loans, 41. Remember, Japanese Pearl Harbor, 41. And conventionals are 36. That's the section in the southeast corner, section 36 for conventional, 41 Hawaii for VA loans. Our real estate market is slow to respond to supply and demand issues because of a permanence of improvements. It takes time to get permits and start construction and come to a conclusion and finish. Now, in our VA loan, in our real estate market, we also have to look at the number of occupants that typically are in a building and trends. This is the household or occupancy rates of property. We also look at what's going on in the market. All of this is taken into consideration in the appraisal industry. Appraising recognizes two values. We have the investor value. The investor value is subjective. It's whatever the investor is willing to pay. And we have the market value. Market value is the most probable price a property brings in an open competitive market. If doing a comparative market analysis, you have to have properties that have actually sold. So vacant lots and single-family homes are best suited to the comparable sales approach. In the comparable sales approach, we may have to make adjustments to the comparable. All adjustments must be made to a comparable because the comparable has a dollar amount to start with. Comparable plus or minus the value of a feature will get to be more like the subject. Our mission is to make the property more like the subject. We will take data from multiple sources and then reconcile that to estimate a value. It is a reconciled value sought by the appraiser. Now, the appraiser is required to follow USPAP standards, Uniform Standards of Professional Appraisal Practices. Uniform Standards of Professional Appraisal Practices, USPAP. If the property does not have readily available comparables, we may use a cost depreciation approach. In the cost depreciation approach, we estimate the value as new and deduct from that loss due to any features that cause us to lose value. Functional obsolescence, for example, would be an outmoded or outdated design. Having jalousie windows or inefficient glass sliding doors would be functional obsolescence. We have external obsolescence, things that are caused outside the property boundary. Living across the street from a chicken farm would be an example of external obsolescence. This smells bad, external obsolescence. And then, of course, physical deterioration is wear and tear. As things get old and worn out, they physically deteriorate. It is considered functional if the cost of repairing is recovered. It is considered incurable if not. Curable if it's worth fixing, incurable if not. An income approach to value is used for income-producing properties and for businesses. This takes into consideration a building's potential gross income, the amount of money it could make, losses due to vacancy and collections. When accounted for, this leaves you the effective gross income. Effective gross income is more realistic. The effective gross income then pays the building's expenses. Once expenses are taken out, you're left with a net income. Net operating income is used in the IRV calculation. Net operating income compared to a cap rate will, of course, give you the value. In businesses, one of the things we must value is the intangible of goodwill. If I'm appraising a business, I use the same approaches for all other real estate, a comparable approach, a cost appreciation approach, and then, of course, an income approach. I also will do something called a liquidation analysis, so I can separate the value of the tangible from the intangible. The intangible asset of a business is its reputation. That's goodwill or going concern value. A real estate business investing in property is the real estate investment trust. It's structured like a mutual fund. It, of course, has the advantages of real estate ownership without the obligations for management. Real estate is taxed. The IRS does offer a depreciation incentive for income-producing properties. The depreciation for building only, 27 and a half years if people live in the building, 39 years if people do not live in the building. Office buildings, shopping centers, 39 years. Land does not depreciate, so you must always take out the value of the land. Special assessment taxes. Special assessment taxes are for off-site improvements. Special assessment taxes are used to pay for the cost of roads and put in sidewalks. When calculating for special assessment taxes, remember both sides are obligated. Whenever special assessments are due, always remember to divide by 2. Property taxes are ad valorem, based on value. Property taxes are based on an assessed value. There are exemptions, including the partial exemptions to the homestead. Our partial exemption for homestead allow you to reduce your tax burden by making your tax value less than your assessed value. It is the local government that operates off of property taxes. Local governments are in charge of enforcing building codes and all of your zoning. Zoning for residential is going to be based on density. Zoning for industrial and commercial is based on intensity. It is the local government in charge. If you wish to vary from strict compliance to building codes or zoning, you must request a variance and typically have to show a hardship to qualify. A hardship variance allows you to qualify to have variance from building codes and zoning. Local governments enforce building codes through the issuance of permits and inspections and consequent certificates of occupancy. Everything's done by local governments. Governments can waive their requirement to comply with zoning on their own. They have special use exception. Government can build anything they want, special use exception. Special use exception is the government adding in. If you're a private citizen, you can build things while the rules are there, and if the rules change, you're allowed to stay. This is a legal non-conforming use. Legal non-conforming use is said to be grandfathered in, because as you know, grandfathers tend to be non-conforming, but you let them stay anyway. Legal non-conforming use, grandfathered in. Never understood why we spent an entire 3 weeks doing this. Could have handled it in the morning. When we return.